Hey, welcome everybody. Welcome back to the Law Self-Defense Show. Of course, I am attorney Andrew Branca for Law Self-Defense, a modest-sized legal consulting and education practice that focuses exclusively on use of force law. I always forget to say that, but in fact, I realize many of you are new to our audience. So that's kind of who we are to all of you who are new. Welcome aboard. We're very glad to have you here. This is an impromptu live show. I wasn't sure I'd have the time to come back this afternoon, but in fact, after taking my wife to lunch and doing a modest half-hour hike through the Colorado foothills, I am back to talk once again about the attempted murder trial of Michael Barisone, particularly with a focus on the cross-examination of his primary victim, Lauren Kanarek. Kanarek. Sorry about that. So for those who are not familiar with the case, Michael Barisone was a former Olympic athlete in the horse riding sport of dressage. That was some years ago. Now he's a trainer of horses and riders for that same Olympic sport. Lauren Kanarek was interested in being trained by him. He invited her to his horse ranch, I guess it would be, where he has his horses, provides instruction. In fact, he invited her to live in a room in his house on the property. She brought her boyfriend / fiance along with her. And from there, the relationship between Michael Barisone and Lauren Kanarek and her boyfriend went insanely toxic. She, by all appearances, evidence in court, her own testimony, did everything she could to act as mean a witch as one could possibly imagine towards Michael Barisone, purportedly with the deliberate intent of driving him insane, which may have succeeded because ultimately Michael Barisone would shoot Lauren Kanarek twice in the chest, gunshot wounds which she survived, so she is available to testify in court, and fired at her boyfriend, did not hit him, but that got him 2 charges of attempted murder as well. Of course, this was in New Jersey, so he got a gun charge as well. And that's what the trial is doing right now. So if you see, and we will see, Michael Barisone as the defendant in this trial, his demeanor is that of an insane person. We see Lauren Kanarek on the witness stand on cross-examination, and her demeanor is that of an unbelievably hostile and malicious and sociopathic and narcissistic witch. So it is in effect a witch. It would be a witch trial if she was on trial. She's not, of course. She's the complainant here. Michael Barisone is the defendant and respondent. So that's where we are in this case. And the defenses here are really, there's 3 possible defenses. Well, I guess 3 plus a wish. 2 of the defenses would be what we call perfect defenses, which mean they would relieve Michael Barisone of all criminal liability for his conduct, for his shooting of Lauren Kanarek and shooting at her boyfriend / fiance. The first of those is the defense of insanity, but this insanity is a very high threshold for a legal defense. Essentially, Michael Barisone would have had to have believed that he was shooting a Martian or a robot or a monster, not shooting a human being. That does not appear to be anywhere in evidence. It appears that he did, in fact, know he was shooting a human being. He might have been under incredible psychiatric distress and pain because of Lauren Kanarek's conduct towards him, but it seems unlikely he meets the threshold required for legal insanity. If he were found legally insane, acquitted on the basis of insanity, he would have no criminal liability. He would still be subject to indeterminate, perhaps lifelong, institutionalization. He would not be released until the doctors in charge of his care concluded he was no longer a threat to society, which could happen in a few months. In theory, I would suggest he's not really a threat to anybody who doesn't treat him like Lauren Kanarek does, but he could be in there forever. I mean, the doctors could say he's never safe to be released. So that's would be the outcome if he were found not guilty. He would not simply be released back into society if he were found not guilty by reason of insanity. The other perfect defense here would be self-defense. And by perfect defenses, again, I mean defenses that lead to 100% relief of criminal liability. If his conduct was self-defense, then the shooting simply wasn't a crime. It was justified conduct. To qualify as self-defense, of course, it has to meet the 5 elements of self-defense. We summarize those for all of you in a free infographic. In fact, let me pull up our little infographic file here. I believe I have it. Hopefully I have it handy. There we go. So these are the 5 elements to make up any claim of self-defense, at least the maximum of 5. Sometimes one or more of these elements is legally waived. It's not required, but for our purposes, and given that this is New Jersey, all 5 of these elements are required for a valid claim of self-defense. The elements are innocence, imminence, proportionality, avoidance, and reasonableness. We list those in this infographic, which you can download for free. We don't charge a penny for it. It lists the 5 elements and provides a brief description of each. If you don't understand these, you can't possibly understand self-defense law. You can get this free downloadable infographic at lawsolfdefense.com/elements. In the event you're a self-defense instructor of any kind, we do have a poster-sized version of this appropriate for framing in a classroom. You can get that at that same URL. That's not free because we have to print and ship those. But if a poster of this were of interest, again, you can get it at the same place, lawsolfdefense.com/elements. So these are the 5 elements that would need to be present for Barisone's shooting of Lauren Kanarek and shooting at her boyfriend to be legally justified as self-defense. In summary, he needs to be able to articulate a reasonable perception of an imminent, unlawful, deadly force threat from them in order to be justified in using deadly defensive force against them. I've seen so far no evidence of really any of those elements. Certainly on opening argument by the defense, which I listened to and shared with all of you a couple of days ago, the 45 minute opening statement by the defense spent maybe 95% of that time talking about the defendant's emotional distress because of the conduct of Lauren Kanarek, and maybe 5% on the theory of self-defense without even really putting forth a robust narrative of self-defense. The defense mentioned, for example, that apparently Michael Barisone had been beaten and bitten by the couple's dog, but didn't even bother mentioning that whether or not this happened before the shots were fired or after the shots were fired, which obviously would make a pretty substantial difference. And so far in the cross-examination, so earlier today, we watched the first hour of cross-examination of Lauren Kanarek by the defense. And again, there really was no substance on self-defense, legal defense at all. Lots to do with how mean she was to Michael Barisone. But you don't get to shoot people because they're horrifically mean to you, because they're bullies, because they cause you emotional distress. That's not grounds for the use of deadly defensive force. So, yeah, I see in the comments, someone says, the beard makes you look like a recovering drunk. I feel the same way, but my wife likes it, so she won't let me shave it yet. So that would be the legal defense of self-defense. So far, does not appear to be particularly robust. Now, the state, now that self-defense is raised as a legal defense, the state does have to disprove it beyond a reasonable doubt. But it doesn't look right now like that would be all that difficult to do. So I don't see either the defense of insanity or the defense of self-defense justification being particularly viable here. Those would be the only defenses that could lead to an acquittal. New Jersey does recognize the legal doctrine of imperfect self-defense. Imperfect self-defense, unlike normal self-defense or perfect self-defense, cannot lead to an acquittal. But what it can do is mitigate what would have been a murder conviction to a manslaughter conviction. And generally, imperfect self-defense exists when the defender had a genuine good faith, subjective belief in the need to use deadly force in self-defense, but that belief was objectively unreasonable. It was irrational in some way. And it may be that Michael Barisone's mental state had degraded to the point where he did subjectively have a genuine good faith belief in the need to shoot Lauren Kanarek and fire at her boyfriend, but that perception was objectively irrational. In that case, if it's not objectively reasonable, it can't qualify for perfect self-defense, but it may still qualify for imperfect self-defense. and his what would have been an attempted murder conviction would be an attempted manslaughter conviction. It would be mitigated down. So that's possible. The fourth defense is not really a defense of all, it's kind of a wish, and that is that the Lauren Kanarek and her boyfriend can be shown to be so unbelievable, sociopathic and narcissistic, and so vicious in their emotional and psychological destruction of Michael Barisone, that the jury, simply out of sympathy, will not convict him for shooting them. That can happen. The jury doesn't have to explain to anybody how it arrives at a verdict. So that's a possibility. It's not one I would want to count on, but perhaps that's what they're trying to do. Again, folks, I'm going to take this down, but this is our free infographic on the 5 elements of self-defense, and you can get that at lawofselfdefense.com/self-defense. All right, so that's kind of background on this before we jump into the video today. I will be happy to answer questions posed if they are posed on the Law of Self-Defense members page, where this ought to be streaming. Let me take a quick look and see if, oh, you know what? I may have messed that up. I think I forgot to set up the member streaming. Sorry, folks. Sorry, members. But I will post it up after the fact, and you can watch it live on YouTube or Rumble. If you're watching this on YouTube live, you can comment. But if you'd like of course, comment to your heart's content. If you'd like your comment answered, to make sure it's answered, it needs to be a super chat form. Otherwise, it just gets lost in all the others. Also, if you're watching on YouTube, if you could do me a favor and pound, good and hard. That's what she said. That subscribe button. We are this close to 30,000 subscribers. It's just that would be a nice threshold to reach sometime soon. So if you could hit that subscribe button, you need to subscribe to comment anyway. So that would be greatly appreciated. If you could hit the like, thumbs up, leave a comment, all of that tricks the hostile YouTube algorithm into letting more people know about our shows. So that would also be greatly appreciated. So again, pound that subscribe button. Pretend it's the prom. All right, let me run my little intro, and then I'll mention our sponsor, and then we'll dive into the video. So here we go. All right, here we go. Oops, that sounded awful. I got to check the audio on that. Sorry about that, folks. All right, before we jump into the video, I do want to mention, of course, our sponsor of today's content, which is CCW Safe. CCW Safe is a provider of legal service memberships, what many people call self-defense insurance. In effect, CCW Safe promises to pay its members legal expenses if the members involved in a use of force event, and those expenses in a killing case can easily be hundreds of thousands of dollars. In even a case where all you do is display your gun in self-defense, don't fire a shot, don't hurt anybody, that checks all the boxes for aggravated assault with a firearm, good for 10 to 20 years in jail, and for many tens of thousands of dollars in legal expenses. So if you don't have that kind of money stuffed in the mattress, just in case you're compelled to defend yourself or your family against criminal predation, it can be helpful to have a partner standing behind you with the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because it does. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. They're by far the best fit for us out of all the companies that purport to offer similar services. Whether they're the best fit for you is something you can decide, but I would urge you to at least take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do become a member, you can use the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 to save 10% off your first year membership with them. And finally, one other mention I want to make is we are hosting a series of webinars, free, 100% free Law of Self-Defense webinars, where we do myth busting of self-defense beliefs, false beliefs, common internet myths on when use of force is permitted and not permitted. We have a whole series of these, I think 7 or 8 of them over the course of the next 4 weeks or so. They're all the same, so you'd only want to attend one, but they are limited to 100 seats each. They're 100% free, but they are limited to 100 people each. So if you're at all interested, I would encourage you to sign up for your free but limited seat sooner rather than later. And you can do that at lawofselfdefense.com/hard to convict. Again, I guarantee you these are going to sell out fast, folks. They always do. 100 may sound like a lot of seats, but it's really not, given the size of the law of self-defense community that we reach. So again, I would encourage you, if you want to participate in this 100% free law of self-defense hard to convict webinar, just point your browser to lawofselfdefense.com/hard to convict. Okay, let's get to it. I'll pull up the video of the second hour of yesterday's cross. Let's see, I believe it's this. It's not that one. It's not that one. It's this one. Here we go. And we'll open up with the judge, Stephen Taylor. And we'll step right into the second hour of the cross-examination of Lauren Kanarek by defense counsel here. And again, what we're looking for from defense counsel, ideally, is either, well, we're not going to get evidence of towards an insanity defense, because that wouldn't come from Lauren Kanarek. It would come from a psychiatrist, psychologist, and the defense does have those professionals lined up as expert witnesses for later in the trial. So we won't be looking for evidence of that insanity defense here. We'll be looking for evidence, or at least questions about self-defense. Like, isn't it true you charged the defendant, you beat the defendant, you sicked your dog on the defendant before he fired those shots at you? Now, the defendant, Lauren Kanarek, could deny that, but at least if the defense is asking the questions, they're pursuing the defense of self-defense. If they don't even ask the questions, there's nothing there to ask about. So we'll see what happens. By the way, I'm as naive to this second hour cross-examination as all of you. I have not seen this. So we're all watching it, or at least I'm watching it for the first time. I expect many of you are as well. I expect what we'll see is what we saw in the first hour of cross-examination, which is a lot of questioning about how horrible a person Lauren Kanarek was towards this defendant. And she's not shy about it. She readily concedes that she was about as horrific a monster towards this defendant, emotionally and psychiatrically, as you could possibly be. I mean, she was seeking to destroy him mentally, emotionally, and perhaps she did. I mean, ultimately, he felt compelled to shoot her. That's pretty extreme. Unfortunately for this defense, because someone treated you poorly, meanly, sociopathically, narcissistically, with malice, those things don't privilege you to shoot them. To be privileged to shoot them, they have to have presented in the moment you chose to fire that shot as a reasonably perceived imminent threat of death or serious bodily injury, one which you, in New Jersey, because New Jersey is a duty to retreat state, one which you could not avoid by withdrawing in complete safety. And I've yet to see any questioning, much less answering, consistent with that theory of self-defense. So I think we'll hear mostly about how horrible Lauren Kanarek is. In other words, that wish, either the imperfect self-defense or the hopeful wish that the jury will perceive her as such a horrible person that they'll acquit the defendant based on that. Not something I would trust particularly. In any case, here we go. Let's see. Let me just get ready to answer the next series of super chats. I'll pull that up now. Okay, none in yet. Good. I wouldn't expect any. There is one. Contrarian. Yes. Okay. I do see. Thank you for your additional super chat. I'm sorry I missed your question at the end of the show earlier today, where we covered the first area about Blood Meridian by Cormac McCarthy. If I recall correctly, Cormac McCarthy wrote The Road, if that's right. I think so, which I quite enjoyed. I thought that was very well done. I have not read either visually or on audiobook, Blood Meridian, but on your recommendation, I will certainly check it out. So thank you very much for that. That's greatly appreciated. Why live in New Jersey? Someone asks, if you can't keep and protect yourself and property. Well, New Jersey is like many of these hardcore, progressive anti-gun states. Despite its reputation, much of New Jersey is gorgeous. It's beautiful country. Once you get out of the part that, buffers right up against New York, where all the petroleum plants are. The coast is gorgeous. The around the Delaware Water Gap is gorgeous. A lot of it's just beautiful country, much like a lot of California is beautiful. Unfortunately, you got to deal with the politics if you live there. And part of the politics is they'll make it very difficult for you to have a gun, certainly almost impossible for you to carry a gun in public for personal protection. And if you do use it, they're highly likely to put your use to the test in a trial, far more likely than in a state like Oklahoma or South Dakota or Texas. Although all those states have liberal cities too that will conduct themselves in their jurisdiction, much like New Jersey or California would. And so that's just the reality. There's a reason I do not live in New Jersey or New York. I mean, I've lived in both those states, and I think parts of them are lovely, and not today. I mean, I barely hang on in Colorado. So always looking towards Texas. That's how it is for me. All right, folks, I'm going to go ahead and hit the start of this, and we're back with Stephen Taylor. By the way, when you hear all the paper rustling and the heavy breathing and the pen clicking, that is not me, okay? That is this judge doing all that right in front of his microphone. It's maddening. There's nothing I can do about it, and it tends to drown out the other parties in the trial, so I have to do what I can to try to maximize the volume, which can... Sorry, it can be somewhat annoying, but I'll do my best. All right. Here, Long Beach. Kevin McCulley mentions Long Beach. I have family that lives in Manahawkin, which is right down the street from Long Beach, and it's gorgeous. It's beautiful there, right on the coast. Absolutely beautiful. But it's New Jersey, so you deal with New Jersey politics. All right, here we go. Again, the cross-examination of Lauren Kanarek, who appears to have intentionally driven this defendant mad, which is terrible, but does not privilege him to use deadly defensive force upon her. Now someone's using tape, for God's sakes. Maybe we'd like to live in a world where you were privileged to use deadly force against someone who's maliciously trying to drive you insane, as appears to be the case here, but we don't live in that world. There's the defendant in the lower right. His demeanor in court is that of an insane person. I'm not a
I will resume
psychiatrist.
Cross-examination by Mr. Belinkas.
Thank you.
Go ahead, sir.
Belinkas is the defense attorney, the guy with the New Jersey
I'd like
hair.
to talk to you about these tape recordings. On August 3rd, Michael Barisone calls 911 and the police arrive, correct?
Well, I'm assuming yes.
And after they talk to him, they come and talk to you, correct?
I should mention, in the first hour across, this defense attorney came
At
across
some
as
point they talk to you.
incredibly weak,
Yeah, at some point
very
the
poor
police-
control of
And
the
on that
cross,
day,
asking
told
poorly formed
the Washington
questions
Township
that
Police
provide too
Department
much wiggle
that you
room
were
to
secretly
the
recording
witness. It's
private
just not a good
conversations, correct?
criminal defense
Correct.
job here.
Did they ask you any questions as to how you were doing this?
I don't recall. I just remember something about just make sure it's something that you own because make sure it's not attached to a phone or in a living residence because that could be considered wiretapping. And I said, no, they're not there. It's on someplace.
So this witness, Lauren
would be
Kanarek, who had
considered
been
my
the victim
property,
of the shooting,
and
she
it's
had
not
set up
attached to a
recording
phone or a
devices
living
around this
quarter
horse
or
ranch,
anything like
I guess,
So
to record
it's your
private
testimony that the
conversations.
Washington Township
If you
Police
did
Department
that in a place where the people recorded had an
Discussing
expectation of privacy, it could be illegal
the
wiretapping, a
legality
crime in and of
what
itself, or on
you
their
need to
phone.
do.
But if you do it in a place where there is no
No, it's my
expectation of
testimony. They
privacy,
were
a barn
offering
open to the
insight
public or
into
open
what
to many
be
people,
careful
then
If
arguably
that's an action
it's
you're
a
going to
permissible
take,
recording.
They're saying
Uh,
just make sure that
Also,
you do, you
I
don't
presume that New
do
Jersey is a one-party
things
state,
because
meaning
they're
I don't mean
definitely
political
illegal.
party. I mean
So-
only one side of a
You were told they
conversation
were
has to
definitely
be aware of the
illegal.
recording.
Or they're definitely.
There are
Judge, I'm
states that
gonna
are
object.
two-party states where
We
both
just talked about
sides
this
of the
at
conversation have to be aware of the
break.
recording for it to be
This is what
lawful.
was told to her, Judge.
Fine, by the police. If you frame the question that way about what the police said, it's fine, but not anything further than that.
Correct. So the police told you you can't record in someone's private areas, correct?
In someone's like private home, or like you can't bug a phone.
So this was a
So,
ranch with multiple
those
buildings. There was a
instructions.
residence
Did they
where
ask you
she and
specific
the defendant
questions
lived,
on-
and he had allowed her to
on
live.
How and where?
When he
you
allowed
were
her to live
doing
there,
the
it's almost
recording?
impossible
No, but I was
in New
sort of,
Jersey
like, telling
to
them,
get
I
rid of a
wanted
tenant
them-
once
I
you've
wanted
allowed them to move
know.
in.
I don't remember
He
how
tried to
far
have her.
into it I
Well, he
went,
asked her to leave many
but
times.
I
I
wanted
think
to
the
be
day
sure,
or the
like I
morning
said,
of the shooting,
when
he
we
tried
go,
to. He finally
that
filed
I
eviction
wanted to make
papers,
sure
but even
everything
then
we
it
were
can
doing
take
was
months.
legal, and
But then
we're
there were
going about it
other
the right way.
buildings. There was a barn.
And-
There was a
and
clubhouse.
at any point
All
in
of
time
those
since this incident,
generally open to
as the
anybody on
Morris
the
County
property. So
prosecutor,
arguably that would
or
not be
any
an area
representative
where you would have a
ever
reasonable expectation
questioned
of
you
privacy, and
about
therefore
where you
recording would be
put these
lawful.
recordings and what the circumstances were behind them.
Believe so.
Who
What?
did you talk about these recordings about in the prosecutor's office?
I know it was in their office, I'm sure, just, and
I sometimes cannot understand this lawyer's questions. I mean, the
Just,
multiple
uh,
pronouns, the compound structure. I'm not sure he knows
Did
what
you
he's
I
trying
don't
to
know
get
whoever
at.
else was in their office.
Did you
It
tell
was brought
Christopher?
up, I didn't go further. than that.
Did you tell Christopher Shellhorn where you planted all the recordings that you made?
And of course, the
regarding
problem
this
with compound
I don't believe
questions,
I
which
specifically
are really
discussed
not
where they
permissible
were.
anyway.
Didn't really wanna,
But the problem
into
with
that.
them
We're
is,
discussing
one, you don't know what
more
part
the fact
the
that,
witness is
someone was
answering,
murdered.
and two, the
and
witness
where
can
was
answer in
someone
the
recording
negative to one
on-
part
in,
of the
you know,
compound
where it
question,
was
and then
placed.
appears they're answering negative to both parts,
Isn't it a
and
fact
still not be lying under oath.
that you did record conversations in a private residence?
No, that is not a fact.
Did you record conversations in the clubhouse?
No,
Did you record conversations in either the residence?
And this
where
is
Michael
ridiculous.
Barisone lived?
He
or
has the recordings.
the stable area where he.
At least the only recordings that will, all the recordings that are in evidence, this guy has them. He should
so no, he
know
never lived in the stable area.
if there were
ever.
recordings in the clubhouse or in the
lived
residence. So
in
he
the
knows the
clubhouse,
answer is going to be no.
which
So why is he
there was no
asking these
recordings
questions?
there. But, yeah, the second portion of your, I guess, questioning.
The second portion of your
is
question, because it's
not
another
accurate.
compound
So,
question,
if maybe you
just
could
poor
ask it
form.
again. Michael Barisone never lived in the stables,
Well, he lived in the club area, correct?
which is separate from the stables, to be
Correct.
clear.
And is
Correct.
it your sworn testimony
Mhm.
that you never recorded any conversations in the club area?
That's correct, unless it was recorded on our person and it's one of us speaking and we were in the club area, which we were not during that time. So I would have to say, yes, it's correct that there was no conversations in the club area recorded,
I've been provided over 70 recordings.
okay?
Where were those recordings made?
My locker.
Every single one?
No, not every single one. Somewhere in our own house,
This is the woman that got shot.
somewhere in. I
Shot
don't know-
twice
I
in the
don't know if
chest.
They were there. I know where they weren't.
Now,
I can tell you that.
interestingly
I know they
enough,
were not.
it may
know
be
that
she
they were
got
in
shot
the
with
locker
ball ammo because
we were
hollow point
recording
ammo is illegal in New
like an
Jersey.
open space
Not for
where
the police,
anybody
of
could
course.
be
The
at
police
any
are allowed to
time.
have it.
Well, again,
Normal
when you say
human
an
beings are
open
not allowed to
space,
have hollow point
Mhm.
ammo in New
Under
Jersey.
your
So
testimony
it's
that you
quite possible
secreted
that she
the
was shot with
recordings
ball,
in an area
which would
where
help
you
explain
or
why she was
Robert
shot twice in the
Goodwin were
chest and
not
survived,
present.
because the rounds almost certainly would have just passed
Well, we
straight
were
through,
present 'cause we
unless
had
they hit her
horses
eyelashes,
still
of
there.
course, and then
Well,
So-
they
when
would
you
have
say
stopped right
present,
there.
I mean present during the actual conversation.
Yes, if you're asking if there's conversations that happened while we were not in the actual stable area, yes, there were conversations that happened during that time, correct?
Okay, and you've indicated that you didn't do that in the club area, correct?
Yes,
How about Michael Barisone's private office? Did you or Robert Goodwin ever put a recorder in Michael Barisone's private office and record private conversations?
No, his office is in the clubhouse, in the club area. And
It's a
that's what I
separate
just said.
room, correct?
Sorry, say it again. I missed that.
His office is a separate room from the club area, correct?
His office is literally inside.
Oh,
the
Vincent
club area.
says he lives in New
There's a
Jersey
door,
and Hollow Point is
but
readily
it's in
available
the
at every
club
gun
area.
shop. That's good
And
to know,
again,
Vincent. Maybe they changed the
Since that
law.
was also their living area.
Again,
no,
I don't claim to have
not
great
go ever in the
expertise in
living
gun
area
law. When I lived in the
accordance
New York, New
in
Jersey
my
area,
locker
which admittedly
or
was
in
quite
the
some
area
time
we
ago,
were living
Hollow Point was
at the
illegal for
house.
civilians.
So
But
again,
perhaps
to answer your
perhaps
question,
it's
it
changed.
would be no. I'm sorry if I'm maybe being confusing.
Okay, so again, in a roundabout way, you answered my question. I'm just going to ask you specifically,
Mhm.
irrespective of how the room is positioned. Did you ever secretly record private conversations in Michael Barisone's office?
No,
If you don't have a recording in hand of her doing that, asking her this question simply opens the door for her to say no and makes you look silly.
Ms. Kanarek,
yes.
who got this recorder?
My boyfriend ended up buying it.
Rob Goodwin, correct?
Yes.
And when did he get
So
that
the
recorder?
boyfriend was
It
shot
was
at.
ordered on the
He wasn't
morning
hit,
of
but he was
August
shot at. And so
31st
that's the
at
second
around
count of
8:07
attempted
a.m.
murder.
From Amazon, to be clear.
August 31st,
I mean, sorry, July 31st. July 31st.
and arrived next day?
I believe arrived the next day, correct?
Amazon Prime.
And so
Overnight.
is it your recollection that over 70 recordings were made from that point on to the time of the shooting?
There were 2 devices, I believe. I could be wrong. I don't know how many recordings there are, but there could be 100. Still, the fact remains, this is where they were, and this is where they were not. They were in my locker. They were in the house that we were living in. We were talking to ourselves. We have that on record. Where they were not was in anybody else's living quarters, including the club room or any other living residence in the farm whatsoever, unless that living residence belonged to a horse, which it didn't. It was in my locker. End of.
Now, you just mentioned that there are 2 devices.
Correct. At least, I believe so. I wasn't in charge of them.
Okay,
But,
who was in
yes.
charge of them?
My boyfriend was in charge of them, but we
Did
both
they-
knew where they were.
Okay, and you were the one instructing him where to put the device, correct?
We would discuss it together. It was no like I'm instructing him or he's instructing me. We had a specific reason for my wanting them to be in my locker, a very specific reason.
Oh.
I guess he had a reason too, but nevertheless, like I said, that's where they were put. A locker which I was paying for.
Did you turn over both of those recordings to the prosecutor's office?
We turned over everything. I was I was shot and dying. The police collected what they collected. I was in a hospital for 3 weeks, in a coma for 4 days. I don't know what happened during that time, but certainly I had no knowledge of what the police were doing or any other office was doing. But I do know that we turned over everything that we had because it was taken upon search and seizure of the crime scene that unfortunately your client committed.
Okay, now, with regards to these tape recordings,
Mhm.
when you recorded something, did you bring it back to your house and listen to what?
Yeah,
on the
the
tape?
judge is interrupting where
Sometimes.
he's issued orders that certain lines of
How did you
questioning are not
listen
permissible,
to
or
those
where the
recordings
defense
at your
lawyer is
house?
referencing evidence
What
that's not
device did you
admissible. or
computer, I
where
think. I think you just put it in the
he's
computer and
asking
plays.
compound questions where it's impossible to get a coherent answer out of the witness. That the judge is
I
supposed to
have
make
no
sure
idea.
the
I'm
judge
pretty sure
is
you
really
do it
serving
anyway.
the
Anybody
jurors,
should delete something, but
trying to ensure the
our
jurors
goal
get
wasn't
some
to
kind of
delete things,
coherent,
it was
maybe true, maybe not
to
true.
get
That's up to the
information
jurors to
they're trying
decide.
to get, which
But
was
coherent
vital to our
testimony out of these
life,
witnesses. If you're
and ended
asking
up
incoherent
exactly coming to
questions,
fruition.
the judge is certainly within his rights
So
to
a few days, just a
speak
few days
up
later.
to
I don't
compel
list the
clarity
exact
of the
way, I would
questioning
say it
so that
was,
we have clarity of what the testimony
heard
means.
on those audios.
So I can have a moment, Judge.
This guy's just lost. I mean, you know, he could lose this line of questioning to this narcissist, this sociopath, and still have been a good lawyer. Unfortunately, not being a good lawyer makes it a lot more likely you're going to lose on this line of cross.
Porch?
I'm not sure which porch you're referring
The
to.
porch in front of the stables.
Porch, no, porch, no, like I said, and I don't mean to, like, sound like I'm being rude or repeating myself or
You're
anything
not,
like that.
you're not, don't worry
I
about
just
that.
want to let you know, the only place that the recorders were ever placed in that barn area at all was in my paid-for locker. That's it. Otherwise, it was on our person or in the apartment that we were living, and that's it.
I wonder if that bailiff eats at Jersey Mike's. Looks like he eats at a lot of Jersey Mike's.
Now, whose telephone number is 973?
Oh, please tell me you know the answer to this question.
7703.
My father,
And that's one of the persons that you claim gave you a legal opinion with regards to recording.
The bail is at attention now.
one of the people and again, I said, I don't really remember which said what or who said who,
Okay,
but I
do you
certainly spoke to my father a few times and
remember your dad saying on August 2nd, 2009?
Objection.
Has to do directly with this issue, Judge.
What doesn't matter? It's still the rules of evidence. Isn't that a hearsay statement?
Judge, I believe it's permissible to impeach her. There's a discussion with her father regarding admissibility.
Wait, isn't this what we discussed at the break?
No, Judge, this is a specific statement which contradicts what she said.
Approach the bench. That click was the judge turning off his microphone. Why he can't leave it off all the time, except for the 1% of the time he's saying something, is beyond me. Oh, ba. Any super chats? Let me take a look. None I haven't already answered. All right.
All
right. Hold on, the objection's overruled, so go ahead and ask the question in this one area.
Ms. Kanarek, your father's number is 973-713-7703, correct?
correct.
Did you have a discussion with him on that day with regards to the
On what day? I'm sorry.
Yeah, that hasn't been made
That's
clear
on
what day it is.
August 2nd, 2019?
It's like using pronouns. It's
At 9:24
ridiculous.
PM. With regards to him questioning the admissibility of you making these recordings.
Yeah, but he is questioning the admissibility rather than legality of it. Then I'm guessing probably spoke of whether after these recordings have been recorded, whether or not they might be admissible in a court of law. since you just mentioned the word admissibility.
Hey, for law
I'm gonna
self-defense
find out
members,
that
it is streaming on the
I don't
membership
think we're
site.
talking
So
about, like, is this legal, is it not legal? We may
although
have been.
maybe the
I think the real crux of what we're discussing is just like you said a minute ago, the admissibility of it.
should be working.
Meaning, will this be admissible at a later date? And that's what you're asking, which it seems to be that is, but I could be
Okay.
wrong. So.
All right,
You
folks,
were-
for those of you coming in late, if you just put your
Given
questions in the
those
comments, they get
copies of
lost
these
in the,
recordings,
there's
correct?
hundreds and hundreds of comments. So
I
if you
don't
have a
remember.
question
I
you
don't
want
know
me
how
to
to
answer,
share
make sure
them.
you put it in super
I'm
chat
really not
form
that tech savvy.
so I can,
Isn't the fact
YouTube
that
allows me
you're
to
aware
pull
that
those up
Your
separately.
boyfriend, Robert Goodwin, had given your father a number of these texts, and you were aware of texts, recordings, and you were aware of that.
But on August 2nd, like I said, it was ordered the morning of July 31st. They arrived probably the next day, if we're lucky. So by August 2nd, I can't imagine there would have been very many recordings by that time. So I don't know what he could have sent in that one time, like time period, or like a small period of time to my father, but I can't say he hasn't, so maybe he did. I honestly don't know. It wasn't me, but yeah,
Okay, and,
if it happened,
and when you use the term admissibility,
yes.
that had to do with the lawsuit that you, your father, and Robert Goodwin were talking about filing against Michael Barisone, correct?
Probably. and I
So they were
just thought,
threatening Barisone with a lawsuit,
things
threatening to
too.
take everything he owned, destroy his life,
Now,
ruin his reputation, and they were
He also
doing
made
things
videos,
towards those
put
ends. I
video
mean, these were
cameras
really,
places,
really horrible
correct?
people.
In our living
Again,
space,
none of
yes. We were planning to
None
go
of that
away the
justifies
following week with
the
Michael, in fact,
use of
to a
deadly force
show,
in self-defense,
which I had signed up for.
and none of it appears to have
It's on the USGF website.
driven him
Check.
literally insane
I
in the
had
legal
entries
sense,
for a show the following
meaning that he
Wednesday.
did not know that he was
where
shooting at human beings.
Michael was to take me to a show, the one we were discussing earlier, in Socrates, New York, called Hits on the Hudson. And we wanted to have surveillance in the house for when we went away, since there was tension on the farm, you know, people going back and forth with their moods and tempers. So all I knew is I had a show, we wanted to have surveillance in our house that we were renting, and we had cameras, Blink cameras, I believe, in the house, or when we were not home. That was the purpose of them, so yes, to that question.
and when you say or said in certain posts that you have eyes and ears everywhere
Yes,
that can't be detected, where were the eyes? Are those the
the eyes are
areas
in our house, which if no one's living there, why would they be detected unless someone's coming in? It shouldn't be.
Well, presumably this lawyer passed the bar, just like every other lawyer.
Who's Rosanna
It's a pretty low
Williams?
threshold, folks.
A good friend of mine, also, she is one of the best international horse sales people maybe in the world. And I purchased 3 of my international competition horses from her. And we're very good friends, and also a business friend as well.
Okay, now, when did you get these cameras that you're talking about?
I didn't get them. My boyfriend did. I don't remember what date, but somewhere around the same time as
When you say-
audios.
Same
Somewhere-
time, that would be after the,
Somewhere around the same
I don't think
time
there's
as
any
audios.
advice that
and you're sure
someone
of that?
mentioned in the comments
No, I'm
that,
not sure of that.
they believe
That's why I
that
said
in
I'm not
other
sure. I didn't
trials
get that.
I've covered,
Okay, where did he
many
get
with
them?
Nick
I
Ricada,
think you ordered them online.
that
like,
appeared the
or
defense was
something.
actually
guessing.
aware of our commentary and analysis because they appeared to change their
Do you remember
strategy
having
in the
a
courtroom
conversation on
to
April
reflect
20th
some of our suggestions.
with
I
Miss
don't think there's anything
Williams?
I could suggest to this
Saying
lawyer
April
just-
20th? I'm
that
sorry,
he
I
would
April 20th,
be able to implement in a
2019.
productive way.
I
Justin,
think if the intention is to refresh her recollection, which she's saying she doesn't remember, she could certainly be shown something to see if that refreshes her memory. I don't think it's
That's the way to do it,
appropriate to read it
Mr.
as
Blankus.
This defense lawyer keeps trying to testify. He's trying to get things into evidence before the jury that have to be brought in a particular
I'm
way. A
showing
witness
you
on the stand has to testify to them.
a
He
text
can't.
message
The lawyer
and the
can't
number,
testify.
Prosecutors
He's not supposed to testify.
April 20th, 2019.
Thank you.
I'm going to ask you to look at item number 9311
This is April 2019, did you say?
Yep.
Okay.
and ask for you to read that.
Just read it to yourself,
Oh, okay.
just to refresh your
Just
memory.
the little yellow Post-it thing?
No. This,
Jesus.
I
Just make
just
sure I
pointed
heard.
right out to Judge Simpson.
Yes, go ahead. Point it out where you wanted to read.
Okay. This is to Rosanna, correct?
Yes, this is you talking.
Yeah, her very verbose responses on cross-examination, which should, in a perfect trial, the answers should be yes and no answers. Maybe you draw out some color from a witness if the color
Right.
would be favorable to your defense.
You bought cameras.
But allowing her to give
I
these
said
lengthy,
that I did with
verbose,
my friend months before.
narrative answers
So,
just
but there was
diffuses
no
all the
cameras.
energy out of the
So
defense
you lied
cross.
to your friend about purchasing cameras
Yeah.
because you thought Justice was a threat? Justin was a threat?
Yeah, I feel like she was worried about me. To make her feel better, I said, don't worry, we have cameras, we'll be fine. We later did get cameras, but it wasn't until months after.
You take this. But you'll agree that there was a text message between you and Miss Williams where you indicated on April 20th, 2019, that you bought cameras last night to plant in the
Mr.
barn.
Belinkus. You just refreshed her recollection. And
I
that,
know, Judge,
I know, but and that now,
now I'm impeaching her with her recollection because it says here, they planted.
well, no, don't read it. That's the whole issue. You use that to impeach her credibility, right? And refresh her recollection.
Right.
And you're saying her last statement that she said is not accurate about what's in there?
Yes, Judge, absolutely. Did you tell her that you planted
She just said she
cameras
did
in
say
the
it, but she didn't
apartment
mean it.
and the barn?
Is this the thing you just showed
Yes, the
me?
thing
Judge,
you
it doesn't say the apartment, it says our apartment.
Yes, exactly.
Our
He's leaving out key words
Yeah.
every time that he reads these text messages to the
All right,
witness.
Mr. Shellhorn. If you have an issue,
Shellhorn is
It's
the
not to be
prosecutor
said in
who was
front of
just
the
speaking,
jurors.
the
all right,
12-year-old.
I understand, but just say you want to be heard at sidebar. And you have to make sure you read everything accurately.
Yes. On that day, to Miss Williams, did you say Justin is a threat, a big one? We bought cameras last night at Home Depot to plant in the barn and in our apartment so we can always see what Justin is doing and saying.
Yes, I said, I wrote that, I lied to my friend, so she wouldn't be worried. There was a situation with Justin that she knew about. I didn't want her to worry. I just told her, don't worry about it. Got cameras, handles, and that was it.
Now, at some point, you know that Michael Barisone knows that you're recording him, correct?
Yeah, but
For those who are
5 months
asking,
later,
I
4
might
months later,
I might do
that
I
was
probably
legal,
will do
correct?
today's cross-examination of this witness because believe it or
the
not,
shooting,
we're
then
watching the
he
second
shoot us
hour
and
of
kill us,
this.
that was August
That wraps
7th,
up yesterday
August
afternoon when the
So,
court
yeah, so
adjourned for
several
the
months
day.
later
Uh,
is when we purchased.
It continued this morning, so there's even more
Is that what
beyond the
you're
2 hours
Yeah,
here. More
hold on,
cross that
just
happened this morning. I'll
listen
probably
to
cover
the
that
question
tomorrow.
and try to
I mean, I
answer
gotta be
only the
honest.
question. As I said earlier,
I'm probably
if you don't
scaring away audience. I
understand,
don't expect it to get
just
better.
say, I don't understand. Can you rephrase?
Okay, yes,
Right.
Your Honor, please.
I'll rephrase it, Judge.
Right, I think you should. Go ahead.
You, at some point, you buy cameras, correct?
Yes,
At some point, you start tape recording private conversations, correct?
She disagrees
By
with private.
cameras, yes. Tape recording, private conversation. Yes, I guess that would be an accurate statement, yes.
Okay, and at some point prior to the shooting,
Mhm.
after you started tape recording private conversations, you became aware that Michael Barisone believed or knew that you were doing that to him,
I'm guessing, I told the police, I'm guessing, I don't know what he was aware of. I have no way of knowing that, sorry.
Folks, I can't cover today's proceedings tonight because one of my daughters has a recital tonight. So I'll be at the recital.
August 5th, 2 days before the shooting, did you tell your father in a text message, and I confirmed for sure that they know we have a bug in the barn? Did you make that statement to your father?
Probably, yes, it's in a text message, I made the statement. You're asking, did I make it
I'm asking you,
rather than someone else?
I'll show you this.
Okay.
100C8. Specific item 42. Please look at this specific text.
This video is from yesterday, folks. So if you're asking in the comments if there's court after this, the answer is yes, that court is today. This was the last hour or so of court proceedings yesterday, March 30th. Yeah, I'm speculating on this point, folks, but I just have to believe that Michael Barisone
Yes,
did nothing
that was
to vet
written.
this woman before he
It was-
invited her
Does
to
that
live on his
refresh your
property.
recollection
Because
as
people
to
like this
whether or
don't
not
suddenly become
you
sociopathic
became aware
and narcissistic and
that Michael
witches when they
Barisone
turn 41 years old, which I
knew,
believe was her age when this
or he
shooting
thought
occurred,
that you
when these
were
events occurred.
recording his
She's
private conversation?
assuming she is,
No,
as she
well,
appears
I
to
think it
present herself
indicates-
here. She's been this way her whole life.
Which is that,
Everyone
I
she's
told
ever
the police
interacted with would
officer
know her as this
this.
person.
so I figured probably. when
Asking
it got
anybody
back to
with
him,
previous
they
exposure to her
wanted
would have
continue
revealed to
having
Michael
those
Barisone that
conversations
this
in front of my locker.
this was a
That's-
toxic
they now
person to
know.
allow to live
Like
on
I
his
said, we were
property.
trying to do things
So
as
I
legally
have
as
to believe he
possible.
simply didn't
Because
ask
I can't
anybody.
know what Michael was thinking or what was actually told to him.
Well, what did you
Talking to my
mean?
father here in a text message, so.
What did you mean when you used the word, and I confirmed for sure that they know we have a bug in the barn?
I
What
meant
did you
that-
mean by the term confirmed for sure?
I meant that I told a police officer, meaning that I figured that if it were some problem, they would know about it. Even if it weren't a problem, they might tell. I didn't know like police protocol. So it's just an assumption. I was writing to my father. Again, in the context of that.
I've
whole
been to recitals
conversation,
before,
I
as
would
every
say
father
that It
has.
would make sense for me to say that.
Yeah, what can I say?
We didn't get
It's
into
a
that.
elementary school recital. It is what it is.
Now let's go back to July 25th.
Okay.
So there has been a
Did you post
suggestion, an
ano-
opening statement by the
another
defense that there may have
lengthy
been drugs involved,
post regarding Mary
used by
Haskins
this woman,
and
her boyfriend,
Michael Barisone?
someone in their
Probably.
residence, because there was byproducts
11
of
days after the
Suboxone
first one that I
found
read
in their
about
trash.
King and the
Suboxone
Queen.
is,
And how many days?
I forget exactly what it is, but it's
11 days
something
after.
taken by, I believe,
How many
opioid
days
addicts
before
in
the
place
shooting
of
was
the
this?
opioids to relieve
This one
withdrawal
is
symptoms. Something along those lines, consistent with drug
July
use.
25th.
Okay, I was just confirming how many days later I was in this.
But that still, of course, does not justify him
And
shooting
by
her.
the way, did the prosecutor ever ask you for the receipt from your Amazon account to
I was in a-
determine when you got those recorders?
I wouldn't know, like I said, I was in a coma for 4 days, in the ICU for 3 weeks, unable to speak, because I had a ventilator shut down my throat.
Okay.
And after that, I was on so many pain medications, I really couldn't communicate with anyone. So I have no idea what was said or done. Like, my life was almost ended.
Do you recall saying words to the effect that it turns out once a home wrecker, always a home wrecker? Were you referring to Mary Haskins?
Absolutely.
Did you
Absolutely.
then say words to the effect that then
I mean, they went
Send
through all
home
this
record
morning
realized
with the lawyer
if a
reading
man
these very
did to his
toxic social
wife,
media posts, very
wives,
hostile, very bullying,
what's to
very
stop him from
tormenting
straying again? Did you
towards
say
this
that?
defendant and towards his girlfriend.
6 more chapters, I know them all.
And this
Right.
this
And then-
witness just says, yeah,
And then
I said all that.
did you say
And
immediately
basically,
after that?
in essence, she's
here's
saying,
where
look, these were social media
paranoia
posts.
and jealousy
I'm paraphrasing
set
here,
in.
but her demeanor is, look,
Yes,
these were
so
social
I'm
media
familiar
posts.
with
Social
this,
media
yes.
is for
And-
talking
and
shit
you're
about people. So I was talking shit
Believe
about
that
them.
Mary Haskins
So what?
was jealous of you?
I think she was jealous of a lot of people, and it was just an insecurity that she had. That was my belief, yes.
And
Yeah, the only 3 people who could testify to the actual events of the shooting, the actual circumstances around the shooting, are the shooter, the defendant, Michael Barisone, this woman who was shot,
did you
Lauren.
say a little
Kanarek.
bit later on in that post, when talking about
What the heck? I keep forgetting how to
Barisone
pronounce her
and
name.
Mary
Kanarek,
Haskins,
and her boyfriend, who was
say
also present.
it's
Obviously,
war?
2 of them, Kanarek and her boyfriend, are hostile to the defendant.
Probably.
Mr. Belinkus, when you characterize something, don't you characterize it?
That's what it says. It's war.
No. Before that. You're saying who she's talking about.
Okay,
You're not testifying.
No.
She is. Ask her that question.
understood. The previous statement that I read, you were referring to Barisone and Mary Haskins, correct?
Can you read the previous statement again, so I'm sure?
What's to stop him from straying again? Here's where paranoia and jealousy set in.
Yes, that's a statement that I wrote.
You wrote that, and it's about Barisone and Haskins, correct?
Correct.
And then soon after that, you basically make a statement, and correct me if I'm wrong, where you say it's war, correct?
Yeah, probably. I'd say so.
And correct me if I'm wrong, but going to war was against Barisone and Mary Haskins, correct?
So
I mean,
first
I
of
don't
all,
know.
going to war
I only got
is a
the one
metaphorical
sentence. I didn't get the whole
statement.
context.
But even if it was an explicit threat,
So I
I'm
don't
going to kill
exactly
him in the
know.
text message.
I'm sure.
That's
We're
only
talking
relevant
about
if she
going to
later
war
actually tried to
against
kill him.
anyone else. during this
Absent the
period.
overt
No, but
physical
like I
act of
said,
trying to
I
kill
don't-
him, the
all I'm
earlier
bringing
threat
up
by
is that
itself is
I feel
meaningless.
that needed
Words
some
alone are not
context left
sufficient
out,
to
but
justify
it's
use of
fine. We can
defensive
just go
force.
with yes,
If
I
there
wrote that.
is an actual
I meant
attempt
that.
to
That's
kill,
fine. We can move on.
then the earlier
All right.
threat is relevant because it
Just-
buttresses
Just
the
answer
overt
the
act.
question.
Okay, I'm sorry.
All right.
Now,
God, this judge is smiling at this witness,
and this is a post that
like he doesn't
a lot
know
of
that's a
people are looking
rattlesnake
at, correct?
sitting in
How
that
does she
witness
know
chair.
Because it's Facebook, Judge. and she
Well,
knows
no. Just focus on the issues. And the issue, how many times, Mr. Blank, is not everyone.
Understood.
So what other people know is not really relevant.
Did you say in that state that you will publicly announce using your special talents for collecting indisputable evidence?
I mean, this kind of conduct could be actionable in some civil way. Intentional infliction of emotional distress can be a
Did
cause
you
of action
tell-
in civil court, but it's not a
Whoever
basis for the
saw
use
this
of deadly
Facebook
defensive
post
force, or
later
really
on
any
to
kind of force,
fasten their
in
seatbelts.
purported self-defense.
Yes.
And
A
it's
story
not
like
going to be
this,
criminal.
even told at a distance, may cause whiplash. It's that bad.
Yes, I did definitely said that.
Including extra stories that could only be heard in recordings or videos to be fully believed.
There is
Yes.
no legal justification called "they were mean to me" for the
So,
use of deadly
on this
defensive
day-
force, folks.
Which is July 25th, you're telling whoever's reading this that you have evidence, videos, and recordings, correct?
I thought the sentence was, could you read the sentence again, actually?
Extra stories could only be heard in a recording or video to be fully believed. We talked about recordings and videos, correct?
Talked about that they could only be believed if they were in a recording or a video, which is what led us to later get those two very things, to make sure they wouldn't believe.
Did did you say towards the end, even a one-time Olympian can be cut down to size?
Yes,
And then, oh yes, a war, I fear, may be inevitable.
yes,
And then at the very end, I'll need all the calm of the Dead Sea to stop me from going totally ballistic.
probably, yes.
Now,
So the
Michael
issue of
Barrisone
whether or
was,
not this defendant admits to the shooting. So
living in
normally
his
when you
home,
claim self-defense,
at
it's
the
a
facility,
self-defense
correct?
is
When
a
he
legal
came back
defense of confession and avoidance.
summer
You
of
confess to the
2018,
underlying physical
correct?
conduct and you seek to
I'm sorry,
avoid criminal
I'm
liability
unclear.
on the grounds of
Okay.
justification.
The
It's not,
facility-
I didn't shoot that person,
the-
I have an
the farm.
alibi, I was someplace else.
Well, he
It's,
was
I
living in
shot
one
that
place
person,
the
I
year
did it, I
before,
shot
and
him,
then
but I
another
did so in
place the year
self-defense.
after. So
I'm
I was,
talking about
We have an odd
the
wrinkle
summer of
here where all the
2019,
evidence is consistent
you,
with him.
you were
The gun
living
that
with
was
your-
used, he
your
had acquired
boyfriend
from another
in the
person. It was in
upstairs
his
apartment.
control. That the gun
Correct.
used was
Michael
in his
Barrisone
possession
was
and
living
control,
on the
used to
main
shoot
floor
her
there
and at the
Yes.
boyfriend.
with Mary Haskins and
But
their
he
small child,
says,
correct?
yes.
The defendant here says that there were allegations
that was
made by
his
this woman
house,
and her
correct?
boyfriend towards him in the minutes preceding the shooting
I
that were
assume
so
that was at the
distressful to
time,
him
yes.
that he has basically he lost his memory, his
You were
recollection
living in an
between
apartment
that
and
moment
were
those
not paying
accusations
him
were
any
made
rent, correct?
all the way until he
For the apartment.
regained
We were paying-
recollection
it was a
in the
barter
hospital.
agreement.
And
So
when you
he
say
has
barter
no
agreement,
actual personal memory of firing the shots. Now,
You were paying
I mean, normally that could be enough to lose
for
the legal
two
defense of
horses at
self-defense,
$2,500
not get a self-defense
apiece.
instruction read to the jury all by itself,
correct?
except
Plus
there's
I
sufficient
believe
other facts in the case
$40,000
consistent
I
with
just
him
given
doing the
him
shooting, and he's
for
not denying
horse
the
he
shooting.
was
He's just
unable
saying
to
he can't
sell.
remember.
Plus,
That he'll probably get the
the work
self-defense
that my
instruction,
boyfriend
but
had done along
getting the
barn
self-defense
and house,
instruction is not
which
going to
Michael
be
said
very
was
helpful
going to be compensated.
absent
um,
really
part of that
any evidence
compensation
consistent
was
with
that
those five
he had the
elements of
housing, whatever,
self-defense,
all
folks.
of it was
Innocence,
established
eminence,
the year
proportionality,
before,
avoidance, and
and that
reasonableness.
the
Any evidence that he
main
was
part of it
facing
would be
a reasonably
my
perceived
other
imminent
horse
threat
that I
of death
purchased
or serious bodily
would come
injury,
overseas.
and
so Michael
he
could
had
train
no
her.
way to safely retreat under the
chose
circumstances.
the
There's
facility
like
to
zero
be
evidence there.
quarantined at. So yes.
So
we
while the
were
state
paying
has
a
the
lot of
burden of
money,
disproving
more
a
than
claim of
just the
self-defense beyond a
$5,000 to be
reasonable
set
doubt,
to living in that
that's not
apartment.
that hard to do when
There
the
was
evidence
the
in favor
work
of
done, like I
self-defense
mentioned.
approaches
There was
zero.
the money given to him for the horse that he couldn't sell. And so, yes, we were living in a house and paying money. Yes,
Again, let's break this down if we could.
sure.
When you first come to his facility, you
Mhm.
only have two horses, correct?
When I first come, yes.
So
And the agreement
jury
was
nullification, folks, is both
that
a
you would
thing
pay
and not a thing.
$5,000
It's not a thing in the
for
sense
those
that
two horses.
it doesn't exist
Mhm.
as a recognized
he
legal
agreed to give
doctrine.
you
There is
living
no
accommodations,
jury nullification, jury instruction.
Training of
The
those two
lawyers are not
horses
allowed to argue
living
jury
accommodations
nullification to the jury.
And
The jurors are not allowed to
Sorry,
argue
more
jury
important,
nullification
yes.
to each other.
Okay, so
That's not permissible conduct
that's the
because it's
deal
not.
that, did
law.
you cut that deal or did your father cut
That
that?
said, nobody
it was a
knows
joint,
what jurors are actually doing
guess,
in
conversation,
deliberations,
discussion.
particularly not what any
Who
one
pays for
individual
the
juror is doing.
for it?
So if one individual
What do you mean?
juror is
Who
aware
pays
of the
$5,000?
concept of jury
You and your
nullification
father.
It
and
comes out of my
decides,
money
hey,
and
if
my
I
father
applied
gets
the
the
law,
check.
this defendant would be
And where
guilty,
does
but
he
I don't
get
like
it?
the law, so I simply won't apply it. I
Okay.
simply will vote not guilty
Okay.
every single time we
So-
have a vote.
Your father's
No one would
taking
know
the
he
money
was
out of
applying
your
jury
account or
nullification
his account?
doctrine, and therefore,
My account.
What's
Yeah,
the,
does it-
and he's
does it
not
matter,
required to
Mr. Billings?
explain how
What's
he's
the
concluding
relevance
not
of this?
guilty.
I'll move on.
So you can
So
do
the
it
original deal
jury
was
nullification
that
in
you
that
would
sense.
board and train your horses.
But he's not going to be
and
able to allowed to
give
argue
you
to other
living
jurors
accommodations,
about jury
correct?
nullification.
Correct.
And these
That
lawyers are not going to be
original
allowed to
agreement did
argue
not
jury
include
nullification
your
to the jury.
boyfriend living on the property, did it?
I told Michael I was bringing my boyfriend and then I had two dogs. I wanted to make sure he knew that in case there was a pet issue or whatever. He sat on the phone in an hour-long conversation, no problem. And then he sent a text to my father, which read something like, she's gonna love the apartment, they're gonna love it. It's so wonderful, it even has antiques. My father then sent me that message, I read it. I said, all right, sounds like a plan. I guess I can't really say no to this offer. It's too good to be true, or refuse, and we took the offer gratefully.
Shane, if you have an example of a Georgia
Did you ever
judge
tell the
overriding
prosecutors
jury
that
nullification in
in
a
the
trial
beginning you didn't know your boyfriend
in
was
Georgia, send me
don't know.
the
I
case
don't think
citation.
so,
I'd love
but
to
I
see
can
that.
look
Or there won't be a case citation. It's a trial case. But send me some identifying
So
information
when
for
you
that
came
case.
up from
I'd love to
Florida
learn more about that. That would be
after the
extraordinarily
winter of
unusual.
2018,
Mhm.
how many horses were you boarding when you first came up?
When I first came to meet Michael, you mean?
Yes, in New Jersey.
And there's
How many actual horses?
It's going to be a hard sell, folks.
two, the same
It's going to
shoes
be a
in
hard
Florida.
sell to the jury that this woman and her boyfriend
And the same
knocked the
arrangement,
defendant unconscious, took his gun, and then
basically
shot
held
each other.
true, correct?
He shot her in the
Correct.
chest
Until
twice
things changed, yes.
just to scam
boarding
this
two
dude.
horses for $5,000
Mhm.
and a living accommodation, correct?
Correct.
Okay. And then there came a time when you brought in two more horses, correct?
There came a time when I purchased a horse from Michael, making that the third horse, or sorry, making that third horse.
Correct.
So that was a horse that Michael wanted off his hands. I paid for the horse. We agreed that I pay for the horse. The horse gets to stay where he's lived his whole life, and no changes made. Training will be included because the horse has shivers. He's got a lot of health issues, yada, yada. Bottom line, I say, Michael, here, I'm gonna give you this money for this horse. He's got these issues, but he shouldn't be moved from his home. So I buy the horse from Michael. He then says, okay, you just buy the horse. He'll keep the stall. You'll keep taking lessons on him like usual. Nothing changes.
Okay, now what's the name of that horse?
JT.
Now, correct me if I'm wrong, you're making it sound as if you took some lame horse off his hands.
Mhm.
That's your position?
My position is that the horse had issues, health issues, serious ones, including Cushing's, shivers. I can name a bunch of other things, really bad case of shivers. And yes, I bought the horse because I had ridden him all the time. Others didn't get along with him. I did. I fell in love with the damn horse, excuse my language. And I bought him. And Michael agreed that it was probably best because probably he wouldn't get anywhere near the money he would have gotten.
When a judge
Had the
does
horse
a verdict
not had these
notwithstanding,
issues.
a
So
judgment
I bought him,
notwithstanding the
paid
verdict,
a lot of money for
it's
him,
normally when
kept
the
him, and then Michael
jury's
invited
voted
me to bring
to
yet another
voted
horse,
guilty
and
and the
then
judge
another
decides
horse.
that's an insane
Yes.
outcome.
Okay,
No
let's-
rational jury
let's
could
talk
have
about
determined guilt
JT.
on the
Okay.
evidence and law before
we
them.
do that,
And he
Can I
changes the
see
verdict to
counsel at the
not
bench,
guilty
please?
in favor of the defendant. Going the other way is very different, folks. A jury that votes to acquit, for the judge to find that defendant guilty, that would be bizarre.
Mr. Belenkas, go to another area, please.
All right, so 2019, you have two horses, you buy JT, which makes a third horse,
I
correct?
just,
Correct.
it's
You're still
unimaginable
only
to me
paying
what
$5,000,
any of this,
correct?
the number of horses, the
5,000
horse was
plus
sick.
The 30 or 40 that I just paid Michael for the horse that I got from him, yes.
Okay, that has nothing to do with the monthly fee that you're paying.
It has nothing to do with
That's
anything.
correct. It's not a monthly fee. That was a one-time payment, done, finished, horse sold.
Okay, and then you get another horse, correct?
No, I already had, well, no, I already owned those horses.
Did you bring another horse to Barisone's?
Yes, I bought
facility?
a fourth horse named
When was
Symphony.
that? When was that?
May, there's a post on Facebook actually.
So
you should
if she
have it,
brought a fourth horse, that
where
justifies
she
the
actually
shooting?
arrived that day, and
What
we're
day?
like, whatever the day, maybe June 7th, I want to say.
Well, so what? What if she
No.
brought 8 horses and didn't pay for board? That's a
They
civil
weren't-
matter.
Okay,
I don't
and sometime in June.
That doesn't
correct?
justify
believe in
the use
June.
of
It might
deadly
have been
force in
earlier.
self-defense.
And can I assume that you started paying another
All right,
$25?
Mr. Belinkus, I just ruled on this. This is not, I find this not relevant. For the reasons I just stated at sidebar.
This is totally different.
All right, Mr. Belinkus, move on. My ruling stands. I don't find it relevant.
I certainly understand that.
Ms. Kanarek, at some point in time,
In
You
almost all
bad-mouthing
states, it's the
Michael
jury decides
Barisone.
guilt or not
people
guilt
in the industry
only, and the
on
court
social
decides the
media,
sentence.
correct?
The jury normally has no role in deciding a sentence,
You-
unless it's a capital
people
case,
that
and
he
then they do have a role
abuses and
deciding whether
neglects the
capital
horses,
punishment should
correct?
apply. There are a couple of
I don't know if I
states
said
where the
all
jury
that,
does play a
but
role
it could
in
be
deciding
correct.
sentence.
Did happen,
Either
so
recommend a
I
sentence
might
or
have
they
said it.
determine the
You
sentence.
even
I
called
believe
him
West Virginia is one of those, but I don't think New Jersey is
believe
one
I
of those.
called
I
him
think New
criminal.
Jersey follows the
It's possible.
standard
I'm not gonna say it never happened.
practice
Well,
of
did you claim
the jury
that
having nothing
that
to do
flood
with the sentence,
that
only having to
occurred
do
at
with
the
finding
farmhouse
guilt or
when
lack
he
of
was in
guilt
Florida
on the
with
charge
Mary Haskins
and lesser included.
was an insurance scam?
Yeah, I probably claimed that on Facebook somewhere. Yes.
You don't have a specific recollection
No,
of telling people that he committed insurance fraud?
no, I only have the specific recollection of what he himself said about it. I don't remember whether or not I decided to go blabbing on Facebook about it
So,
that day or not.
could their
Maybe I did.
conduct
I
towards this
sometimes do,
defendant,
not my
apparently
best choice.
intentionally driving him crazy,
But it could have happened.
could that be a mitigating factor
And you
in
realize
sentencing?
Insurance fraud
In
is a
theory,
crime,
yes.
correct?
Unfortunately,
I
when we're
realize
talking about
And so when
sentences
I
like
Ask you
murder,
the question,
um,
did you
usually
accuse him
the
of a
threshold
crime?
is life in
You
prison.
realize by
So there's not
calling
much
him
to mitigate
someone who's
there.
committed insurance fraud,
if-
that is accusing him of a crime.
I suppose in theory, we could have
I mean,
the defense
yeah,
arguing
you go to the
imperfect
police about
self-defense.
it and
New
report
Jersey
him,
recognizes the doctrine of
'cause then if I
imperfect
didn't have
self-defense, or
exact
even a conviction on
proof,
attempted murder. The
I don't
judge
want to
could
accuse him
mitigate
of
that.
erroneous
So
report.
the jury finds him
So
guilty of attempted
I was
murder.
expressing my
They
feelings
could
on it
argue imperfect
based on what
self-defense
we
to the
had
judge. The
heard him
judge could
say to
mitigate
us
that to
himself.
attempted
And we very much
manslaughter.
believe that
Manslaughter would have more of a
At one
range
point, he
in
did not want the
sentencing, and then
information
their
that we had
conduct
about that
of
getting out.
Lauren
Well, then, you
Kanarek and her
told everybody
boyfriend
on social media
could be
whatever
argued as a factor
you
in
thought you
mitigating
had,
the sentence
correct?
within the range for
Probably.
manslaughter.
Now, you contacted Safe Sport, the town, maybe other agencies? Did you ever contact
yeah,
the
I
insurance
don't-
company and
I
give them
don't.
this?
I don't think
evidence
this
that
defense
you
lawyer
had?
is B.
No, I did
Ivory
speak to the
Lamar
insurance
tier.
adjuster, though,
I think he's
and
below
he made it very
B.
clear
Ivory
that
Lamar tier.
had
I think
some-
in terms of
I don't know,
skill
I
set,
don't know how to
they're probably
articulate it.
roughly
He
equivalent
had
in
some
terms of.
arrangement with Michael, and he did not
arguing,
discuss it,
questioning,
and he left.
But at
But
least
I just
Lamar
wanted
brought
to ask
theater
him
to the
a couple
table, and this guy
questions.
doesn't bring that.
And he wasn't having it, so I left it alone at that point.
You just said that you were aware of the fact that Michael Barisone didn't even negotiate the fraud claim. There was a private adjuster that did that, correct?
I'm sorry.
You talked to
Yeah,
him.
I saw that
There was
interview
somebody
of
that said they were
Prosecutor
a
Binger
private
from the
I'm going to
Rittenhouse
object
case
at this point to the relevance. I think this is getting.
by the either. I thought it was the president of the New York Bar. It may have been the American Bar Association, but I thought it was the New York Bar. In any case, whoever this legal authority
He brought
is
out that she
asked
accused him of
whether Binger would
insurance fraud.
appeal the acquittal of Rittenhouse. prosecutors can't really appeal
No.
acquittals,
That's
folks.
what's relevant.
That's
So
not how
move
the
on.
criminal justice system works.
Sustained.
Now, 3 days before the shooting,
Unless there
were you
was some
posting on
substantive legal error by the judge, something really
that
grievous,
everything from my
just
life,
completely misstated the law.
livelihood, and even
But
writing
once the
career
defendant is acquitted,
have
that's pretty
all
much
been
it.
threatened, should I refuse to adhere to the things I've been put through constantly?
I did, yes. Right that.
Yeah, so if you
And
ever go to a
who's
criminal
threatening
courthouse,
your
folks, you'll see
life.
And
some
my
guys
lawyer, as
in
you read,
not very expensive suits,
Michael
hanging
Barisone
around,
and his
wearing
girlfriend
ties,
Nina
having
And how are
briefcases,
they doing that?
and these are criminal defense
Several
attorneys
ways.
who
They were calling
whose clients
farms
don't come to them. They
and
basically go to the
trainers
clients to hang on the
from
courtroom. They look for people
Michael's
who look
higher
like
up,
defendants who
powerful
don't know what to do,
Olympian friends
people charged who don't know
to
what to
your
do. They
average,
approach them, ask
you
them
know,
if they
next
need a
door
lawyer, and
barn,
basically they're
telling them
ginning
we're
up business
menaces,
right there in the
we're
courthouse.
torturing them, we're terrorists.
There's nothing necessarily wrong with
And
that.
at the same time,
I mean, if I were
you know,
starting a
we-
criminal
like,
law
we need
practice
to leave,
today,
or
fresh out
they
of
didn't
law
want us
school,
there, so
I might do much the same.
I guess
But you're not
in
likely to be
best way
picking
to
up
describe it
a
is
very
they were
good or
trying to- they're
experienced
trying to-
criminal defense
we
attorney
felt they were trying
in
to
that
trap
way,
us there, saying,
just drifting around the
"Oh, you know, you
courtroom
have to
because
leave,
those
my
guys
girlfriend
don't
doesn't
get
like
their
you, but-
clients that way.
oh,
Those
yeah, you
guys
also can't
have
go
an
anywhere
office and their
else."
clients come to
You've been
them.
calling every single place, telling them, don't take their horses. That was happening.
You-
And the girlfriend was calling, not just calling, Michael and the girlfriend weren't just calling, they were actually going so far as to cyber stalk all of my social media pages back to up to like 5 years to see if I'd ever had a conflict with anyone, and then get that person involved in this dispute.
Well, they should have done
Whether
that
I'd not
before
spoken to
they
that
brought
person
her
in 5
in to
years,
live there as a
2
tenant.
years, 10 years, it didn't matter. They were doing things that were not okay by any of the governing bodies of the
And looking
sport,
at someone's internet history
by
that's
any of the
publicly
governing
available
bodies
is not
of all the
cyber
sports,
stalking,
and quite
folks.
frankly by the law.
That's not what stalking
since they were
means.
cyber
Stalking
stalking
would be if
When
they
you
were
say
pursuing
cyber
her
stalking your page,
in a
you
harassing manner
indicated that
across
they
the
were
internet.
Contacting people that knew you, correct?
I don't know who, among them, yes.
Okay.
And also other people. Michael wrote in a text message to
How
some
did you
woman,
see the text message?
Twitter. It was posted publicly on Twitter,
Okay. that
that Michael posted literally these words: "I'm a very big guy in the Olympics. I have a lot of power here, whatever. I'm good friends with the with the CEO, Murray Kessler, and the chief of staff or the chief counsel, Sonia Keating. I have a lot of power there. Like basically, once you got into the Olympics, you have all this power. So, I'm gonna be able to do whatever I want." Encouraging this
He
person.
said, I'm gonna be able to do whatever I want in that Twitter.
Something like that. I'm paraphrasing most of these things, like you sort of have a little bit, but yes, in the instance that you're discussing, yes, on Twitter, it's public, posted publicly, the text message that Michael Barisone wrote to this person saying, "Mary Haskins said she found you online. She's never met you. I'm this big guy in Olympic sports. I have a lot of friends. I'm good best friends or good friends with the head counsel, Murray Kessler, who's the CEO. The lead counsel, Sonia Keating, good friend as well." Basically asserting his power, that he's this big Olympian who can bully us peons into submission in whatever way he wants on an temper tantrum, and get others involved in doing it.
What do they call
which
this?
is safe
Bully
sport is an
crying?
abuse of power.
When a bully gets
which to
called
the
on their
law,
own
I'm sure,
behavior,
is
they
cyber
find
stalking.
something
I don't
about
know.
the other person's
And
behavior to
the
cry about,
USCF,
make
our
themselves look
oversight
like the
body,
victim.
would also be weaponization of the oversight body and a violation of their code, as he well knows.
And you think that by him contacting these people and talking to them about you and what is going on, specifically the postings that you're making?
This is not
The bad
this is
mouthing
not
that you're
legal
doing
argument.
with
I
him
don't even
and
know why
all
the
his
judge is
staff,
allowing
that there's
this.
something
He's like
inappropriate
a friend
with
of
him
Michael's
checking you
who's
out
getting into
or
an
conducting
argument
an
with this person who's been
investigation
harassing
as to
Michael,
who you
like they
really
bumped
are?
into each other at the
I'm
supermarket
sorry,
or at a
I
bar.
missed the question in that.
That's the reason that you just stated in your last answer is the reason why you claimed in this post that your life and livelihood have all been threatened.
Yes, when an Olympian blatantly says to someone in a text message, I am going to ruin this person's life.
Who said that?
Michael said it. He said,
There is a text out there or any post.
Can you let her finish, Mr. Belinkus, please?
I'll withdraw the question. Is there any,
actually, I do
Post.
believe there is a text out there
Okay.
that he wrote.
okay, did you give that text to the prosecutor for him to
No.
use in this courtroom?
No, I do not.
Where is that text that you just said Michael Barisone said he was going to ruin your life?
Oh, we heard him saying it. We heard he texted people this, saying he's going to ruin our lives and, quote, find a way to make our lives hell. We got wind of the fact that he was in fact doing that when we spoke to
If he's got a legal argument for the defense, I've yet to hear it.
I'm sure it'll come in later. But like I said, for all the world to see, he put on display by texting this woman that he is this big guy in Olympics and that she, in fact, a person who's not even a horse person, should immediately call these oversight bodies and make complaints against us. And this is a person that I had a personal dispute with that ended.
We got about
years
15 more
prior,
minutes of this nonsense,
and
folks.
was telling her, make this complaint and don't worry, it's okay. I'm a big guy in Olympic sports. No one's gonna, that's how the text reads.
Was that,
I'm sorry, what was the question?
was that,
Don't even think about going there, Mr. Belinkus. Move on.
Okay.
We're going down a rabbit hole here. Move on.
I have to concur with the
yes or no
judge.
answer, if you can answer that way. Is there a text message to support what you
There
just
needs
said
to
in
be
your last answer? where
Some
Michael
overarching
Barisone
structure,
said he
narrative
was
that
going to
ties into
destroy
whatever
your
legal
life?
argument this lawyer is trying to make, and
Yes
I
or no?
can't see one.
If I recall correctly, there is.
Okay.
I would
And-
not swear my life on it, those exact words were used, but I would testify that some words to that effect were used in the text.
And did you tell that to Prosecutor Shellhorn?
I don't know. I honestly don't
I mean,
remember.
we have
I'm
all
sure
of
I've had
his,
many conversations.
you're aware of the fact that we have all of his texts, your texts,
Mhm.
Mary Haskins' texts?
Judge, I don't know that that's accurate. that we
Yeah,
have-
Mr. Belinkus, ignore that, members of the jury. Ask another question, please.
Or not.
Would it surprise you to know that Michael Barisone doesn't have a Twitter account?
No, it wouldn't surprise me. He has a Facebook account though.
Well, you just said you saw it on Twitter, correct?
Yes, I saw it posted by another person on Twitter.
Another person.
Yes, a text made by Michael Barisone to
I
This
just,
person-
I don't know.
and
I
this
mean,
person
admittedly,
posted
listen, in
a
the
screen-
defense
a
lawyers,
photo of that message on Twitter.
he just may
In
have
fact, there
nothing
were
to work
several of
with, but
Some of them are
a
still
good
there.
attorney would
Some have been deleted and screenshot.
be more effective
Some are
than
still
this,
there right
even
now.
with nothing to work with.
Let me ask you this. Did you ever post something regarding Barisone and Mary Haskins and then delete it?
Not that I recall, unless Facebook took it down or a site that thought like a post was inappropriate, if I edit or delete it. I do not recall deleting any posts. That's more a Mary Haskins thing.
No. You just talked about having, or listening.
She
to
didn't
recorded
delete any posts. That's the
conversations
defendant's
between
girlfriend who
Michael
does
Barisone
that.
and his
I mean,
staff
the
concerning
snark
you.
she's allowed to get away with here on the witness stand is amazing.
Did there come a time when you would use those words to taunt him? His own words,
Taunt him?
yes.
No, I would not call it that.
What do you call when you post private conversations that someone has on social media? Do you think that that would have an impact
All
on?
Can she answer the
Yes,
question?
how many questions? Just one at a time. Let her answer, and then you ask a follow-up.
I would think that since in those very recordings that you're speaking of, he literally says,
Listen, I'm not asking you what he said.
Well,
I'm asking you.
Mr. Belinkis,
She's not answering the question, Judge.
I don't know because you cut her off. I don't know if she's answering it or not.
I'll withdraw the question and ask
I think you should withdraw and move on to another area.
Yeah.
Ms. Kanarek,
Sorry, but you're just not being productive here.
post private conversations that you recorded of Michael Barisone on social media.
yes, I did.
Did you text him?
Yeah, by the way, folks, for
Some of
anybody
the
who doesn't
private
know, if you're
conversations
involved in
that
some
you
kind of
had
use of force
recorded.
event and you're
I
facing criminal charges, the
don't
first
think
thing the
so.
authorities do is subpoena all your social
Maybe,
media,
I
all
can't
of it.
imagine I would text
And that
him,
includes
"I
anything you think was
recorded you saying
deleted.
this."
No,
Uh, It may include
I don't
things
know.
that you
I
typed in the
don't know.
platform and
Yes,
didn't
I'm
even
sorry.
hit send. Everything you
Let's
type on
turn
that
to
platform, they're
August 6th, the
capturing.
day before
You must
the shooting.
presume.
Okay.
So if you're going to use these social media platforms, just be prepared.
I-
The day could
do I
come when
have
the
to-
entire
I'm
world
gonna ask you
will
some
see
questions
everything
with
you've ever
regards
put
to
on there.
a
Things you
Facebook
think are
post
private,
that was
direct
posted
messages.
for
The
everyone
police
to
get
see.
all of it.
And this, I'm sorry.
And this is the one where you start off, where you say, some advice to all couples, never give an ultimatum.
Yeah, this is
remember that post?
this is the post you just read a few seconds ago,
No, this
But this
is
is-
totally
yes, it is.
different.
the 6
This is-
chapters.
August 6th.
Well, why don't you show it to her so we can get it clear?
It's not always illegal to tape someone without their knowledge. If you're in a two-party state, that's true. But if you're in a one-party state, you're privileged to record,
I'm showing your.
even if you're the
Facebook
only
post,
person who
page
knows the conversation is being
31,
recorded.
35.
Yes. And I point them now. I don't know if I'm allowed to or not.
I'm gonna ask
Judge, I
you,
think that's page 3135 of S402. Just so the record is clear about what.
Yeah, nothing is ever actually deleted from social media, folks. You just can't see it anymore. It's hidden from immediate
read
view.
this. This
It's
is
still
Facebook.
there
It goes on to
in the
second
background.
page.
Yes, this is the one where you read about the home wrecker girlfriend and VK.
No,
This
this
is the
this is a different one, August
This is
6th.
yes, the 6 chapter post that we read, talked about.
Nope. We haven't gone over this one. This is
Okay.
another one.
Okay, you say so. I'll take
Well-
your word for it.
Okay,
Go ahead.
August 6th, 2019.
Mhm.
Now, you start off this social media post by saying, never give an ultimatum.
Mhm.
Yeah, and it appears that New Jersey
Did
is
you
a
hear
one-party
anyone
consent
in your
state.
secret
So
recording
only one party in the recording
give Michael
needs
an
to know that the
ultimatum?
recording is being made.
I have no idea, probably. Actually, yes, I did. But I don't know how direct they were. I don't know how to answer that question. Yes, there are ultimatums
I
given.
don't know how having
And
two
you
phones
heard
is going to
that
help you
private
unless you can make one of the phones
Who
magically
were the
disappear.
ultimatums given by?
But if anyone's ever seen you with a
Huston,
second
some
phone,
cases,
then the authorities know there's a second phone.
Michael, I believe, in
And
Smother,
they will
Mary
look
DeFranco.
hard. And destroying the
and
physical phone doesn't make the
Credit Bureau.
records go away.
And these were all captured from your locker in this stable area?
That's correct.
Yeah,
They would
of
all
course it's
gather
New
on
Jersey, so they
events.
still have these
and
ridiculous
discuss things.
plexiglass shields
Why they were doing it in front of my locker, I couldn't
around the
say.
courtroom. It's
And there are horses.
you know,
that
once a
go
cult
by.
takes hold,
So,
it's hard to break that
Horses
hold.
typically don't go in living areas. Just
Have you listened to all these tapes? There's not horses going by in
All
there.
right, Mr. Belinkus,
Okay, I'll look
Come
at
on.
that.
enough of the comments, please. Just ask a question, get an answer, ask another question.
With regards to this post, which is the day before the shooting,
Mhm.
you're talking about, and correct me if I'm wrong,
It's
People
not a
that
great
give
way to get rid of
ultimatums
tenants to put a for sale
tend
sign
to
on the
be
house,
miserable
folks.
and insecure people. correct?
That's not. They still won't leave. And then you can't sell the house because the new buyers won't buy the house with the old tenants in there. They won't go to
And
closing.
again, you say, and correct me if I'm wrong, numerous world-class show animals and even managed to get the human husband on an alternate list for a coveted spot in
The
the
judge
Olympics
telling the defense attorney
and
to
produced
engage in
winning
appropriate
competitors
cross-examination is not bias or
we-
misconduct
we
by the
put in,
judge.
uh,
That's the judge
parentheses.
keeping order in his
Again,
courtroom.
just a random example.
I
When you
don't see where you are.
The defense
representing
lawyer
anything.
needs to
When-
be
when you
a
posted
good
things
enough
like that,
attorney to work within the rules for
Did you
procedure in the courtroom.
intentionally make a statement and try to cover your tracks with another statement like, that's only examples, I'm not talking about you, or using metaphors? Did you try to disguise who you were talking about?
Probably, so that it wouldn't be, so I'll just leave it at yes, probably, I think that would make sense.
Will you agree with me that it's clear in this post that you're talking about Barisone and Haskins?
It's clear to me, yes.
Or to anybody that knows Barisone or Haskins, correct?
And that knows I'm training with them and that's where I'm located. And that had they made these phone calls bad mouthing us for what we believe is no reason, they might come to my page and say, okay, there's another side of the story. And I wouldn't have to say a name or out anybody so that anyone else would know. But those people that we discussed were getting phone calls that were not involved in anything going on, would maybe come to my page and say, okay, there's more to this than what we're hearing from their side at the moment.
Yeah, for those of you who've come in
Is it
new,
true
if
that
you
when
could
you're
hit that
making these
subscribe
posts,
button, that
you
would
always
really be
try to
appreciated. We're
qualify
within
things to a
inches of
certain
hitting
extent
30,000
to protect yourself, correct?
subscribers. No one's more surprised than me,
Yeah,
folks, but
probably, yeah.
there it
And
is.
for
We're real
instance, where you
close.
said here, upon this
Where are
hypothetical
we?
husband, in quotes.
We are 71 people away from hitting
Return.
30,000. So if we can get
He had
71
in tow with
more
him a much
subscribers,
younger woman
that would be fantastic.
who
You
hosted
need to be
said
subscribed to
clinic.
comment,
Not
so
pretty.
it's in your
On the
favor.
outside,
Hit the like button,
they're nice.
hit the bell
On the
to get our
inside,
notifications.
just
Don't forget about that.
spiteful,
And if you comment,
adulterous,
that helps
and
the
insecure.
trick the
Did you
YouTube
say that
algorithm,
about Mary
which is
Haskins?
extremely hostile to folks like me, folks like Nick Ricada. It tricks the algorithm into spreading word of our work sooner. So I would really appreciate that. We're getting ready. We're getting close to the wrap up, to the end of this. I do have some wrap up commentary at the end. So if you could hang in
did
there
you
for
say
another
that,
minute or two after
after the
the
divorce,
judge
that Mary
finally
Haskins,
adjourns court for the
she
day,
began discussing
which will
plans
be
to
in about
remodel the
5
home
minutes, I'd appreciate it.
her boyfriend once shared with his wife.
Mr. Belenkus, let me see that sidebar, please.
This is just ugly defense. And yes, we can presume that this woman and her boyfriend were absolutely horrible, monstrous, horrific, sociopathic, narcissistic people intent on this man's emotional destruction. I mean, look at him here. Certainly looks emotionally destroyed. Intent on his professional destruction of his reputation. We can presume all those things to be true, and it still does not justify him shooting them. That's not there. Apparently, he got the pink gun from someone who'd driven up from North Carolina, either to I don't recall the reason, but they came up from out of state, and they lent him the gun. So he's been charged with the gun crime of coming into unlawful possession of that gun under New Jersey law. There are states like New Jersey, Massachusetts, New York, where you need a permit merely to possess a gun. I know that many of you living elsewhere in the country will be shocked. In most states, you may need a permit to carry a gun concealed, although I believe it's 24 states now are constitutional carry states. But in most states, even if you do require a permit to carry the gun in public, you certainly don't need a permit to buy a gun and keep it at home. But in the really hard anti-gun states like New Jersey, Massachusetts, New York, you need a permit merely to be in possession of the firearm, even in your own home, or at least a handgun. By the way, very, very foolish to bring a gun into New Jersey if you do not have authority under New Jersey
All right,
law
move
to be
on,
in
Mr.
possession of that
Blinkus.
gun. They will happily prosecute you to the ends of the earth.
Or is this a good time to break, Mr. Blinkus? It's
I
4:25.
think it is, and
All right.
it's my wife's 60th.
Well, we don't need to get into that. Just tell me yes, it's time to break. All right, ladies and gentlemen, we'll break for today. Please don't discuss the case. All right, we'll see you tomorrow morning, same time.
All right, so that's it for that. Another ugly performance by the defense counsel here. It's what can I say? He just does not come unless it's all a charade. Maybe he's looking to appear incompetent for sympathy from the jury. That's not the way I would play it. It just looks to me like he's not a very good defense attorney. So if you don't have the facts on your side, so you can't pound on the facts, and you don't have the law on your side, so you can't pound on the law, you need an exceptionally clever lawyer there to do effective pounding on the table. And it appears to me this defendant does not have an exceptionally effective attorney for that purpose. I will take a look at the Super Chat questions in just a moment. Also, the law self-defense member questions. Before I do that, though, I do want to mention again to all of you who may have come in late, we are running a series of 100% free law of self-defense webinars. We're calling these the Hard to Convict webinars. They bust a number of common myths about self-defense law, myths that are commonly believed and if followed are really just leading you straight to conviction in prison for much of the rest of your life. So we don't want you to do that. So we're doing this 100% free, Hard to Convict webinar, a series of them. They're all the same, so you would only want to attend one, I would imagine. We have a series of them because each is limited to 100 people. So that's so we can have effective Q&A. But they are only 100. 100 sounds like a lot, but these webinars will fill up very, 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 very quickly, folks. They always do. So if you'd like to grab your free seat at one of the scheduled lawselfdefense.com Hard to Convict webinars, I would encourage you to do that sooner rather than later. And you can do that at lawofselfdefense.com/hard to convict. Also, of course, you can always get a free copy of our best-selling book, The Law of Self-Defense. Free meaning we eat the cost of the book. We do ask that you still cover the cost of shipping and handling to you. That's about $8 or $9, I think. Or you can get the book at Amazon, and then you pay, I think it's $20 or $25 for the book, plus whatever the shipping and handling is. Order it from us, and we eat the cost of the book. We just ask you to cover the cost of the U.S. Postal Service and our warehouse guys who pack these things up, about $8 or $9, and the rest we cover. And you can get the free copy of our best-selling, The Law of Self-Defense Principles book at lawofselfdefense.com/free book. Easy enough to remember, lawselfdefense.com/free book. All right, so let me see. There weren't a ton of super chats coming in, but let me take a quick look to see if we have more. And it looks like Contrarian 420, thank you for your super chat. He writes, he's picking up glimmers of sane and cogent concern in Michael, that would be Michael Barisone, the defendant, as he observes how poorly his counsel is performing in this cross. Well, maybe. I guess I have to say I haven't observed that, but certainly if Barisone's demeanor at the defense table of looking like a person who's completely broken, if it's all an act for the purpose of trying to gain an acquittal, and then you lose confidence in this strategy by your defense counsel, assuming it is an act and that is the strategy, maybe the act dissipates if it appears it's not working. I don't know. I guess we'll see moving forward. And in terms of our member area, let's see. Robert, yes, we got the feed fixed to our Law of Self-Defense members. Apparently, the feed was working to our platinum members, which is how I see the broadcast on the Law of Self-Defense member dashboard as you might imagine, but not on our standard membership. But that's now fixed. Yep. Okay. And the other people are just confirming that. All right, folks. I think that's all we have for today. Maybe tomorrow morning, I'll pull up today's continuing cross-examination. It doesn't look like it's going to be much different than today, but the only way to know for sure is to see. And I believe the state also called the other victim in this case, the victim of the defendant's attempted use of force. He fired at the Lauren Kanarek's boyfriend, missed, but fired at him. That's the basis for the second attempted murder count here. I believe the boyfriend takes a witness stand. That looks like it may be more of an enjoyable train wreck from what I'm seeing in the comments. So we'll probably check that out tomorrow. So if you want to join us tomorrow, we will send out notifications on YouTube. So click that subscribe button, bang that bell, and hopefully YouTube will notify you of our live shows. We'll probably do a morning and an afternoon, just like we did today, covering that distant testimony. All right, folks, that all said, thank you very much for joining me here today. I'll remind you all, as I do every show, that if you carry a gun so that you're hard to kill, which is what I do, I carry a gun, so I'm hard to kill, do it every day, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until tomorrow, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.